discussions. Julie Madheka is a program manager at the International Commission of Jurists, that's ICJ Kenyan chapter. Julie, I want to begin this discussion by reading an article, just a brief summary from the Cambridge University Press. This was regarding the Francis Muratetu case. The decision of the Supreme Court of Kenya in the Francis Karioko Muratetu and another versus the Republic, finding the mandatory nature of death penalty unconstitutional, represents not only a victory of human rights in Africa, but also the transformative capacity of contemporary constitution in Africa and the growing assertiveness of African judiciaries. This case featured prominently during the interview for the Chief Justice and, of course, for the judge of the Supreme Court, right? Let me briefly talk about the finding in that case because it forms the basis for our discussion. In that judgment, the court held that the mandatory death penalty is out of sync with the Progressive Bill of Rights in the country's 2010 constitution, and that's at para 64, an affront to the rule of law. And the court also relied on what you're telling me off camera on global death penalty jurisprudence to find the mandatory death sentence harsh, unjust, and unfair. Let's begin from there. The fact that it's been delivered, it doesn't tie in with harsh, unjust, and unfair. Please explain this, contextualize this for us.
Okay. So, first of all, I believe all civil society organizations that work around the death penalty were very excited about this decision. This was a landmark decision by the Supreme Court. The reasoning being that it actually analyzed the provisions of the Constitution versus the provisions in the Penal Code. So whereas we have the provision on death penalty, we have the provision on the right to life and when it can actually be deprived in the Constitution, it does not state that it's a mandatory deprivation. So the Penal Code actually creates a situation whereby it's mandatory in nature, which is different from what the Constitution prescribes, that right to life can be deprived, if not, can be deprived only if within the law and not arbitrarily. So that's what the Constitution says. So understanding and appreciating that the right to life should be upheld, the right to life is something that should be protected, the Penal Code then creates a situation whereby the now right to fair trial cannot be addressed because the issue was that irrespective of the mitigating circumstances, irrespective of the trial process and irrespective of the issues that have been adduced in trial, the sentence is mandatory, thereby limiting judicial discretion, limiting the capacity of judicial actors to act on the information that they have been given, therefore affront to the judicial process and affront to the fair trial principles in the Bill of Rights.
Hold your thought. What is the concern? The fact that it limits the judiciary or the fact that it's even given?
In what regard?
In the regard that it's mandatory.
The fact that it's mandatory is a concern. The death penalty, ideally because of the fact that it's recognized by our country, is a provision there. We cannot repeal the Constitution with the rule of, with the, how do you say it, with the stroke of a pen. However, the mandatory nature of it is the concern. It should be a gradual process. The death penalty should be given to the most serious of crimes. The evidence should be so overwhelming, the issue should be so grave that the death penalty is given in only those circumstances.
Explain to the viewer, mandatory means there is no judicial discretion.
None whatsoever.
So it means if this kind of crime attracts a death penalty, you have to give it. They don't have like, let's give life without parole, for example. So
that's the thing. Administratively, they had been reviewing sentences to life, commutation to life. However, that is not bound in our Constitution. That is not bound in our laws. So then that's why we went to court, the Supreme Court, to understand how an administrative process is going through, yet the law is very clear on death, murder equals a death penalty. So now we are at a point where we are saying we do not want the mandatory death penalty. We want the judicial officers to look at the cases before them and then prescribe the death penalty in the most serious of cases or prefer other sentences in cases that require a lesser sentence other than the death penalty.
But I think, Julie, this is, I mean, the line is so clear, the line is so fine. But let me take you back now. The fact that this is within our laws and it's mandatory for crimes, I'll not call them offenses, such as murder, right? How comes it's unheard of? I mean, the last time we heard about a death sentence and actually actualized was Kitambo Sana.
Well, there has been a push by African states and the world generally to have moratoriums on countries that do not have the abolition, that have not abolished the death penalty. So in countries that haven't abolished the death penalty, countries have come together and actually signed moratoriums against the death penalty. So in that way, you are not abolishing the death sentence. However, you are not executing. So people are in jail facing the death penalty, but are not getting executed. And that has been the case since 1987 for Kenya.
What happens to them? I mean, I cannot just stay in jail thinking that I'll be executed, and it's not happening because that's what I was given.
And that is the challenge that we have. You find that a lot of people are in jail not knowing when a moratorium will be lifted, if it will ever be lifted, or also when the day with the maker shall be, because unfortunately it is a life sentence because of the nature that it has been created.
And what does that do to them?
It is mental anguish.
Is it a violation of human rights?
It is a violation of human rights. It is cruel, inhumane, and degrading treatment because ideally this person is, in a way, dead.
Yes.
Because they are not considered part and parcel of the society in regards to them being able to contribute even to society because they are facing the death penalty. You find that other people who are incarcerated and are serving sentences can work, can, you know, engage in
These guys
economics.
are even isolated.
They're isolated.
Yes.
So there's a stigma around it. And the challenge that we see is that whereas there is a wonderful thing that the moratorium has been put because it preserves the life, but what is the quality of life?
Okay.
What is the quality of life?
The people who whose families are probably watching this, and there's someone who was found guilty for murder, and we sit here and look like we're trying to preserve their lives, give them alternatives. Probably in other jurisdictions we have life without parole, right? There's no possibility of even review of your case. It means you're in for the rest of your life. And probably they celebrated when that pronouncement was made in court, and then it doesn't happen to them. Don't you think it also affects them? Why is that person still alive? They took the life of someone else. Before we go to women.
Okay.
Yeah.
So just coming back to Murwatetu, so now the decision on Murwatetu has allowed for resentencing in cases of murder. So now persons who have the death penalty and had committed murder can now apply for resentencing. Now the challenge is this resentencing does not apply to persons who had committed robbery with violence and other cases that attract the death penalty. So right now persons who have the death penalty and are serving it in murder cases can apply for resentencing. Which is a bit challenging because a few people are actually serving the death penalty with robbery and violence cases, but that's on the other side. Now, looking at the victim and looking at the persons whose loved one was taken away and therefore they're serving the death penalty, there are two ways to look at it. One, does killing a person give you satisfaction? Does taking away this other person's life bring you any satisfaction? There's been an argument around the fact that it actually does not. You have found that a lot of people have had restorative justice processes whereby they actually talk to those people and they forgive each other and they move on.
Even in court, while the sentencing has just happened, the families, they talk and they forgive each other. So the realization that killing the other person will not bring back this other person. But that's not legal. That's moral. That's a moral question, yes.
So we find that right now there are various people to consider in this whole situation. One, the person who's serving their sentence has a family. This family is stigmatized in community. This family has actually gone through a very hard process because a person's a family member who's serving the death penalty is a cog in your society. So your mother is serving the death penalty. A woman in your mother is serving the death penalty. You are looked at as a child whose mother is errant. You're looked at as a person who should be orchestrated from the society. But at the same time, from the people who want justice, they also feel like justice is not delivered because the death penalty that was meted out has not been fulfilled. So you find that it is a state of lack of justice for everyone across the board. And you have to look at the fact that our criminal justice system is also not perfect. So in other instances, you find that persons who are convicted of the death penalty are people who needed legal representation and did not get adequate legal representation.
That's a question that I'll take back. How then did the case proceed? Because you're entitled to legal representation of your own or chosen by the court. So how did the court proceed?
So the thing about legal representation is that you will have legal representation at the dock. However, and especially for murder cases, the judiciary has been very deliberate about ensuring that you do not proceed with a murder charge without an advocate present. But that is not to say that the advocate and the legal representation that you're getting is sufficient, because sometimes people do not have those advocates. They are assigned to them. And the people who are assigned to them do not have the conviction that you would want to take on your case.
They don't have your best interest.
Okay. Yes, they don't have your best interest at heart. So you find that the case is not done as well as you would want it, with the due regard for, evidentiary collection. Yet you have a fully fledged prosecution office that its sole mandate is to prosecute the case.
Nail you.
Is to prosecute the case to their best possible way. So you find that you're almost playing at a David and Goliath situation. And if you look at even the data of people who are incarcerated, you find that they are uneducated, people who had gone into primary school level, many of them have not even passed secondary and dropped out. You find that most of them are casual laborers. So a lot of the criminal justice system in this realm looks very discriminatory to the vulnerable, marginalized, and poor community.
Okay, and that's the reason why perhaps this outcome was necessary, because now everyone is going back who was sentenced, who's waiting for death, is going back and they want a review, they're asking for resentencing. But my question is, for all these years, what has happened? What is taking place? I mean, it can't just be that we're just somewhere and nowhere. What has happened for all these years to now bring this case to the fore, and now we have civil organizations talking about it, we have international community talking about it. In this space, what has happened?
So a lot of cases have actually led us to this particular position. So you find that in Malawi, they had two cases that were profound, the Kafiateni case and the Jacob Tuboy case. In South Africa, they had the Makwanyana case. And all those cases, to some extent, have fed into our own jurisprudence. So you have in Kenya, we have had the Joseph Kahinga case, which spoke a little bit about the mandatory sentence and how it is a violation of rights. So even as we were going into the Francis Muruatetu case, there were other cases that had already started piling up that have led us to this decision. But in the global movement, there are certain international conventions that have been pushing for repeals of laws and abolishing of the death penalty. So you have the optional protocol against the optional protocol on the International Convention on the Civil and Political Rights. It's a mouthful. So this particular convention actually mandates states to abolish the death penalty. So there has been a global push around that.
Okay.
But coming into Africa, the moratoriums have been very useful, and also the Africa Commission creating a specialized committee to look at death penalty, extrajudicial killings, and enforced disappearances within Africa has taken a deliberate look at what are African states doing. The other thing that has been developed, which is so key for Africa, is the protocol on the African Charter on the abolition of the death penalty. And that is a game changer, because when passed by the African Commission and the African Union, then states would have a way to ratify that and therefore have a legal mandate into the abolition of the death penalty per state in compliance with the African Charter.
Have you done a comparative study, for example, to see which countries still apply this?
Yes, we have data on the countries that are applying the death penalty actively. Unfortunately, some of the data is very interesting. Like the US still executes people. Japan, Iran still actively execute people. In Africa, we have had cases of executions, which is quite sad. But there are gains, whereas we are not yet there. There are certain gains. So yes, comparative analysis has been done. Yes.
All right, let's take the discussion back to women now.
Yes.
This is very important. I know you mentioned earlier in cases, especially in mitigation, the reasons why this will be brought up. But why was the theme this year picked and fashion tailored towards women? Perhaps what was the reasoning behind? Let's focus this year only on women.
Oh, okay. So, as I mentioned, it's a global conversation. And the global conversation focuses on different aspects of the women. So in other countries, women are actually discriminated against because of the stand that they take. I know in Iran, there was a woman who was executed because she stood in the way of her child being defiled. So that was taken as an act of aggression and therefore was executed. You have in various countries women who have been executed because they are considered witches. You have in other countries women who are executed because they are considered to be leading a movement that is contra religion to the countries that they hold.
But the examples you're giving us are extrajudicial. Are they judicial?
They are judicial processes.
Oh, they are judicial processes.
They are judicial processes.
So this woman, like the one in Iran, had to go through court first?
Yes.
Okay.
So it's a very unfortunate situation globally.
Okay.
But now bringing it back to Kenya, the things that we have seen are that women, particularly women in gender-based, who have gone through gender-based violence, who have been systemically abused and thereby killed, are not given the opportunity to use that as mitigation, because it is not self-defense in that particular realm. It fits within the space of murder, because they woke up with the intention to kill the abuser. Mm-hmm. And
it has all the elements.
It has all the elements,
yes.
It's proper, and once they commit that, without appreciating the other issues that were there
around it,
yeah, this person is then sentenced to death.
Okay.
So in Kenya, we are looking at GBV. We're looking at the fact that it has been there. It has been a contributor to certain actions. We're also looking at what it does to the family. So we're not only looking at women as persons who are incarcerated, we're looking at women and their children and their families and the community at large. Yeah. Exactly. But we're also seeing that there are things that need to be done better. We need to ensure that legal representation is given to persons who have and can face the capital punishment. How is it possible that a person who is likely to face a very final and penultimate penalty does not have legal representation? They would say guilty but do not understand what the guilty charge carries.
This person doesn't understand, how comes I was abused for 9 years, this man almost killed me, I did it, and now I'm facing this. They don't understand.
Exactly. Yeah. Exactly. So you find that it's almost as though we are doing another level of abuse. We are secondarily abusing this person.
Okay.
So that is why the emphasis is on women. And women who have been actually commuted and their sentences have been commuted have been speaking out about it and saying how they wish there were various mechanisms to adduce evidence on mitigation around what they went through, because indeed the legal process and the criminal justice process is skewed against the poor, the vulnerable, and the persons who do not have access to legal representation.
And talking about that, whose fault would that be?
Not necessarily a fault. I think it is... right now, we have realized the gaps within the system. Once the Moratorium decision was given, the Attorney General was mandated to constitute a committee that would look at the issues around death penalty. And with that, he actually created a working task force that delivered a wonderful report. And in that report, there were various issues that were highlighted. Okay. Resentencing policy, the role of the National Legal Aid Service, the role of the Power of Mercy Act, and the committee that is there. And a proposal that was given was actually the creation of a parole board, whereby persons who are serving longer sentences can actually, if they have rehabilitated and they have been of persons of good conduct, can actually approach the parole board with the request of early release. Okay. So we wouldn't necessarily say it's a fault. I would say that it has been a blind side in a lot of our criminal justice interventions, and now, because of the various efforts that have been put in, is now a center. Okay. We are now focusing on that and ensuring that resentencing policies consider this. So we now have the opportunity to make it better.
And the question is, has the judiciary embraced this, and even before it's fully adopted, have they embraced it, and now the magistrates, the judges are looking at this as a discretionary matter? Have they adopted it? Have they embraced it?
With the direction from the Supreme Court in July 2021, the judiciary has embraced the direction given. Okay. The challenge that was there was that because of the Moratorium decision of 2017 and the pronouncements, there was a lot of misconception, there was a lot of leeway, there was a lot of latitude that was given to judicial officers because people interpreted it very differently.
Yes.
So with the discretion and with the advisory that has been given by the Supreme Court, now it is very clear. Resentencing will be given to persons who have the charge of murder and have been sentenced to death.
Is there a limit for this? I mean, the number of years they have been in, because I'm looking at several cases.
Yes. We are looking at all the cases.
All of them?
All of them that qualify for resentencing.
Okay.
Remember, we have not said that the death penalty has been abolished. We are saying that now its mandatory nature has been declared unconstitutional. So now you can reapply to court, tender your mitigating circumstances with the hope that your sentence will be reduced. However, the court can also say that indeed the charge that was preferred against you, I mean the sentence that was given to you, which is the death penalty, holds because of the seriousness and the gravity of the offense that you did. So that is the dynamics that you're working in. Not everyone will get commuted to life. Okay. Not everyone will get a reduced sentence, but the people who are deserving now have an opportunity to approach
and the first priority is women.
Yes, I would say that. I would hope that the women actually get specialized priorities because as well, their vulnerability is something to be considered.
But already the women are benefiting from the fact that there are instances that they cannot get this sentence. They're already beneficiaries. I
wouldn't say it's beneficiaries per se, because you cannot get the death sentence if you are pregnant,
exactly.
if you are nursing.
That gives you a benefit. Even if you were supposed to be sentenced, it's not going to happen because of that fact. So you're already benefiting from not. But however, I know the circumstance being in jail for all that, it's still the same thing.
Exactly. Yeah. So I don't, because of the fact that there's a moratorium, so everyone is per se serving a life sentence, even as a woman who is pregnant, and therefore the sentence meted on you is life imprisonment, there is no benefit. You will serve for the longest time, and unfortunately at some point you will have to deliver, nurse, and then give out your child back to your family, back to the community. And unfortunately, if you don't have those, you would actually have to put them in the child protection entities, into an orphanage or something like that. So it's actually dehumanizing to some extent.
Okay, and the end game to this?
The end game to this, the hope that we have is that with the amplification of this issue, with the constant drive for the abolition of the death penalty, that countries will consider abolishing the death penalty within our laws, that we will look at creating mitigating circumstances and allowing for mitigating circumstances to be considered as evidence, and at the same time that we will actually, ascribe to the right to life and freedom from cruel and inhumane treatment, which we believe the death penalty is.
Okay.
Yeah.
All right. In less than a minute, what happens on the 10th now? What is the information you're sending out there, and who are the target audience for this? So
for the 10th, we are hoping that the various criminal justice actors will be party to the commemoration of this date. So we will be engaging with a lot of the women prisons across the country. Okay. We will also be, showing messages around what has happened in other jurisdictions with the hope that it can inform our country. And we will also be now seeking and reaching out to the various entities around what is the abolitionist movement in Kenya and how we can strengthen that. We are also calling on the implementation of the task force report by the Attorney General's office so that these institutions that have the power of mercy, the creation of the parole board, can be actualized within our country. So that is the rallying call we have. Right.
On the 10th, the commemoration will be done. Where is it happening? It's happening across the country, but the main event will be in Nairobi.
It's happening everywhere. Different institutions have different activities planned around the country, so plug in to the ones that you support and the ones that you can. Okay. But the online movement will be very robust on the 10th of October.
All right. Yeah. Julie Matheka, thank you very much. Program Manager at the International Commission of Jurists. That's ICJ Kenyan chapter. Thank you for coming and discussing this with me. My mind is already open to this, and I think it sheds a lot of light, especially for the gray areas. The people who just had Francis Muretetu during the Supreme Court interview and the interview for the judge of the Supreme Court. Now they know what it means.
And thank you so much to KTN for carrying this story. So it's an important conversation that I hope that you continue engaging in.
It is indeed.
Thank you.
So as I let Julie go, time now for a short break, but in the next hour, we still have a lot lined up for you. We'll be speaking to Willie Lusige. Hopefully, Raila Odinga is in Western Kenya. It's the season of politics and politicians are all over. We understand the Deputy President is also somewhere in Kajiado. If I'm not wrong, we'll try and get all that information for you. Plus, a lot of things happening in this country. Today is day 5 of voter registration. Has your new voter, the 19-year-old, taken a voter's card? The ones who turned 19 in 2017, they're now 23. Have they registered to vote? Remember, the IBC says they're targeting between 6 and 7 million. We'll be looking at those stories. But first, a break right here on News Center. We'll be back after this.
This is KTN News.